a minute at the end to help us continue to help you. Now I have the great pleasure of introducing our trainers today. We have Virginia Young, who is our HR Compliance Director, and then we have Astrid Servin, one of our HR Directors, so you are in wonderful hands. And Virginia, it's all yours.
Great. Thank you, Anna. And thank you everyone for joining us this afternoon for our 2026 labor law update. We are happy to be here with you to give you some information you need to know for the new year. And thank you to the City of Glendale for sponsoring this webinar. The City of Glendale provides a number of services for its employers, as you can see on the slide here, especially the free HR hotline where employers within the city can call and get access to a live, very experienced and knowledgeable HR director to answer their questions. We are California Employers Association. We're the voice behind your hotline, and I imagine I've spoken with one or more of you, and Astra's probably spoken with one or more of you on the phone. We enjoy helping you and are thankful to the City of Glendale for the opportunity to do that. We are a human resources consulting company. We offer our members question and answer advice, as well as on-site consulting, a myriad of forms, policies, and handbooks to help them navigate California law, and trainings like this. So we have a number of members, large and small, across California and even beyond California, people with California employees who are located out of state. These are just a few of our members. We have large companies, small companies, associations, you name it. One thing we are not a law firm, and we cannot give you legal advice. This presentation is educational in purpose and should not be relied on as legal advice. If you do have an issue that is legally significant to you or your company, you should consult your own attorney. So let's jump into 2026 updates. Today, we're going to start with wage and hour, everybody's favorite, but it affects our lives every day as employers. We'll talk about some changes to leave laws and benefits for employees for 2026, as well as some new updates in the employee rights area, including some new regulations about artificial intelligence in employment decisions. So let's start off with wage and hour. We're going to start with increasing minimum wages, everybody's favorite for the new year. Then we're going to look at some changes to California's Equal Pay Act, as well as the no tips on overtime and no tax on tips and no tax on overtime, phrases that you may have heard in the news in connection with HR 1 or the One Big Beautiful Bill Act. So minimum wage, the state minimum wage for California went up to $16.90 an hour effective January 1, 2026. This means it was up, from $16.50 last year for 2025, and the increase is based on the increase in the cost of living, the consumer price index. That rate, $16.90 an hour, is the state minimum wage for your hourly non-exempt employees, the amount they need to receive for each hour they perform work. The minimum wage also affects your exempt employees because it dictates the minimum salary that they must have for the exemption. The minimum salary for exemption is twice the state minimum wage. And when you do the formula, it means the minimum exempt salary for your white collar executives, administrators, and professionals is $70,304 annually for your exempt white collar employees. If you are an employer in one of the two industries listed here, either the fast food industry or the healthcare industry, you may be subject to a different state minimum wage than the $16.90 an hour and $70,304 for exempt employees. Fast food chains are covered, if like large chains, fast food restaurants can be covered by California's fast food minimum wage law. The minimum hourly wage for those employees remains $20 an hour. And the minimum exempt salary is also higher based on that higher minimum wage. Numerous employers are covered in the healthcare industries are covered by the state healthcare minimum wage law. And those minimum hourly wages for non-exempt employees currently ranges from $18.63 an hour to $23 an hour, depending on the type of organization you are. So if you are covered by either of those two laws, you'll want to pay attention to those because they are higher than the state minimum wage. They did not have, neither industry saw increases on January 1, but there are some increases in the healthcare industry expected on July 1st. So in addition to the state minimum wage, which was what the last slide was about, we also need to be aware of the local minimum wages in California. There are over 40 local jurisdictions, either cities or counties, that have established a higher hourly minimum wage for non-exempt employees. This is done by local or county ordinance typically, and again, there are over 40 of these localities across the state where these types of higher minimum wages are in place. We do track them. They often increase on January 1st of the year at the bit.ly link down at the bottom of your slide. You can use that to look and see whether cities you have workers in might be covered by one of those minimum wages and whether there was a January 1 increase. Couple things to remember here. The local minimum wage is based on where your employee is actually performing the work physically. That could be different from where your business is located, especially if you have an employee who is working from home, hired remotely to work at home. If they're performing that work in a city with a higher local minimum wage, they are most likely covered by that higher local minimum wage. So I do recommend whenever you have an employee who's working off-site, either at home or at a client site, check the local government website where they're performing the work and see what kind of regulations they might have with respect to employees within their jurisdiction. Okay. One more note on the local minimum wage. I left it too early there. The local minimum wages do not affect your exempt salaries. So that is a piece of good news in our whole discussion about minimum wages today. The local minimum wages only affect the non-exempt hourly salaries. Okay, the Equal Pay Act. California's Equal Pay Act has been the law for a long time. It prohibits California employers from paying employees of another sex, race, or ethnicity less for substantially similar work. So there are some exceptions if there is a legitimate bona fide factor, such as a difference in seniority or merit or production. But for the most part, employees who are performing the same work should be making about the same, unless one of these factors that I just mentioned is at play. In 2026, there were a number of changes to this law to enhance it, basically. And the first one was in 2025 and previously, the law prohibited paying a member of the quote opposite sex less for substantially similar work. The word opposite was changed to another for 2026. And the purpose of that amendment was to encompass non-binary employees and clarify that this law, the Equal Pay Act, applies based on gender identity as well as male, female, binary distinctions. The second thing the amendment did to the law is it expanded the definition of wages. It's not just the base hourly rate or the base salary that you're paying these employees. The law has been broadened to include bonuses, stock options, access to overtime, amount of overtime they're getting, profit sharing plans, other types of benefits like life insurance, vacation and holiday pay. It can also include how expenses are reimbursed and the rates at which expenses are reimbursed for things like hotel or travel. So it's construed quite broadly. And when you're analyzing whether you are paying similar wages for substantially similar work, you want to consider your whole compensation package there. Finally, the new law for 2026 extended the statute of limitations to 3 years for Equal Pay Act claims. Previously, the statute of limitations was 2 years or 3 years only if the violation was willful on the part of the employer. This year's amendments got rid of the distinction between intentional and non-intentional violations, and the statute of limitations for all of them is 3 years. So when does that 3 years start ticking? It starts ticking the last time the employee experiences a violation of the Equal Pay Act. In a lot of situations, this could be the last paycheck they ever get from you, right? That could be the last time they experience the violation. In which case, that's when the 3 years would start going, and they have to file their lawsuit by the end of that 3 years. The final thing that the amendments this year made clear is that if employees file their claim within the 3 years from the last act, the last violation, then they're not limited to 3 years of damages. They can reach back a full 6 years to collect their wages. So remember that even if someone files 3 years after they've left your employment, they can reach back a full 6 years from the date they file to collect for violations of the act. So it's a continuing violation theory. For that, we recommend holding on to your payroll records and wage decisions for at least long enough to cover this extended period. SB 642 was the law that made the changes to the Equal Pay Act. It also addressed pay transparency. And pay transparency is separate from the Equal Pay Act requirements, but it basically requires employers to provide information to employees about what the ranges of pay for these positions are. It's been around for a long time. It requires all employers to provide a pay scale to their current employees for their own position, or if someone is applying for a position and asks for a pay scale, the employer would have to provide that to an applicant for that position as well. In addition, if you have 15 or more employees, all of your job postings have to include a pay scale. If it's possible that the position may be filled by someone in California, it has to include that pay scale. And many states have this requirement, not just California. So it's important to make sure you're aware of that. This year's amendment addressed what does a pay scale mean? What is that number that you have to give employees? A pay scale means the expected range that the employer reasonably and in good faith expects to pay upon hire. In the past, that wasn't very clearly defined, and we were seeing pay scales that were extremely broad because they went from at the bottom what you would pay a new employee with no experience to at the top what you're paying someone who's been doing the job for 20 years. I mean, they were becoming kind of meaningless because they were so broad. So this new amendment narrows that definition. It's what you expect to pay as the employer, your hiring starting range. So other changes in the wage and hour, just to mention the IRS mileage reimbursement rate went up from 70 cents a mile to 72.5, $72, I'm sorry. Yeah, 72.5 cents a mile for 2026. And anytime an employee, exempt or non-exempt, anytime they're using their personal vehicle for business, for not for commuting to work, but for business, they're driving to client sites, they're delivering things or driving on out-of-town travel, they have to be reimbursed under California's labor code for their reasonable and necessary expenses. And this includes mileage and wear and tear on their personal vehicle. The labor commissioner has said that using the IRS mileage rate is a way to do this, a permissible way to do this. And we recommend it because it's an easy way to make sure you're getting the payment right. So this is the expense reimbursement part of it. That's gone up a little bit for 2026. It's important to remember if you have non-exempt employees who are driving around conducting personal business, I'm sorry, conducting in their personal vehicles, conducting your business as the employer, that's going to be hours worked for them. And that means that in addition to getting this payment to pay them for their expenses for their car, they also need to be paid for their time. That's something that often gets confused. But when you have a non-exempt employee driving around on business, you have their time to think about and their expenses. Okay, so the last thing in our wage and hour coverage is HR 1, or also called the One Big Beautiful Bill Act from the summer. And that bill made a number of changes, a number of tax related changes specifically. But we're going to talk today about the qualified overtime and qualified tip provisions that apply to employees through the tax years 2025 through 2028. The bill established an above the line tax deduction so that employees who receive certain overtime payments or certain tips can deduct these amounts from their income before taxes are imposed. Because it's an above the line deduction, it doesn't matter whether your employee itemizes their income tax or not. It helps all taxpayers because it's an above the line deduction. So let's look a little bit closer at what qualified overtime and qualified tips mean, and then we'll talk about what your responsibilities may be as an employer in the future towards helping employees identify what parts of their wages may be may fall within these definitions and be deductible. So what does qualified overtime mean? Basically, that means if the overtime premium that is paid to an employee when they work over 40 hours in a week, right? So we all probably remember that employees get time and a half for hours over 40 in a week. The qualified overtime is that additional 0.5 that they get for the hours over 40, right? What it does not include is other types of overtime that is not for hours over 40 in a week. Okay, so it doesn't include California's overtime for daily hours over 8, or its double time payments that are required for hours over 12, or its overtime payments that are required for the 7th consecutive day of work. So there are going to be potentially a lot of overtime triggering instances where an employee receives overtime. It may or may not qualify for the deduction. It really depends on whether it's for hours over 40 or not. And again, it's only the premium, the additional 0.5 that is deductible. So qualified tips, on the other hand, employees report they're supposed to report that their tips to you. And the trick here is that qualified tips are those that are provided in an occupation that is customarily and regularly receiving tips as identified by the IRS. So there, you really need, the IRS has published this list at this bit.ly link here where you can identify the occupations that where tips would qualify for this deduction. And there are over 70. It ranges from bartending to water taxi operators. It's a pretty long list. So you'd want to familiarize yourself with that list to see if your employees who are receiving and reporting tips to you are in those kinds of occupations that qualify. So what do you need to do for this for tax year 2025? The IRS has said employers are not obligated to report the qualified overtime or qualified tips separately on the W-2 form. However, you will be required to do that in tax years 2026, 2027, and 2028. So we do recommend that you work with your payroll provider to identify your qualified overtime and your qualified tips so that you can report them properly in coming years. For 2025, The IRS has said that employers are encouraged to help employees identify these amounts. They haven't said exactly what that means, but you do need to be prepared for the 2026 tax year W-2s. You're going to have tracking requirements. So if you haven't spoken to your payroll provider about it yet, now is a good time to do that. Okay, so to sum up our wage and hour, just some to-dos in addition to making sure you're doing the overtime and tip tracking that you're supposed to for the OBBBA. You want to make sure your minimum wage rates are appropriate and that they've been adjusted as needed for both the state and the local requirements. We do recommend that you update your wage theft notices for your non-exempt employees to reflect higher rates. You may need to adjust your salaries for your exempt employees. And we often get the question, what happens if we can't afford that? And the answer is, you can convert people to non-exempt. That's often the solution when an employer isn't able to afford the increase. That is an acceptable solution, not always a popular one. And finally, we do recommend that you audit your equal pay practices and update your pay scales in light of the recent amendments. We do have a wage and hour audit and PAGA prevention package here at CEA, which can be helpful to audit these and other important wage and hour issues for your business. And with that, I'll just maybe check in with Astrid here and see if there are any common questions or any questions that she wants me to answer live before I push on to something else.
No, I think they've been fairly simple. People asking a little bit about the definition of healthcare and maybe even certain minimum wages if it applies to them. And my recommendation was just to check in with the definition of a healthcare facility because it may or may not apply to certain businesses. And then, just if in doubt, checking with their counsel to see what if they meet that definition or not. But other than that, I think someone asked about mileage. If it's a highly compensated salaried employee, do we still need to pay mileage? And mileage is for all employees. You may have something agreed upon with that highly compensated employee, but definitely mileage needs to be reimbursed. So anything else you want to add to that one?
Yeah, I would say, if you don't necessarily have to do your reimbursement by the mileage method, you could have some other appropriate arrangement, but that's something you would want to, address with your counsel and make sure it's adequate to meet the needs for reimbursement.
Then we did have someone ask, what does an audit equal pay practice entail? Maybe a little bit more on that.
Yeah, I think to audit your pay practices, just in general, you want to look at your different job titles and job descriptions and look at your pay ranges and make sure that they're within with your pay ranges are stated properly and that they appear to be based on legitimate criteria such as seniority. Any differences are based on legitimate criteria such as seniority or quantifiable, merit or production or something like that. So.
Yeah, good. Yeah, and yet, be sure we don't have any unintentional discrimination going on there. Okay, I think that's it for now. I'll let you keep going. Thank you.
Okay, thank you. Okay, so let's move on to leaves of absence and benefits. A couple new laws to be aware of in 2026. There are some changes to the laws that require employers to give protected leaves, protected time off work for employees who are crime victims. And there were some corresponding changes to California's paid sick leave law in connection. So we'll talk about that. And then there is a new law that places restrictions on the common employer benefits arrangements, such as retention bonuses. That's also important to be aware of in 2026. So those are the two main topics for changes in this area. And we'll start with the crime victims leave. As you may recall, we saw a major overhaul of court and crime victim leave laws last year for 2025. So this year there are further changes, but they're less extensive than last year's. I think it's important for those of you who may not remember last year's changes as well, to go over them briefly before we dive into the changes for this year. Last year, the law that made all these changes was AB 2499, and it gave us, first and foremost, a very broad definition of who is a crime victim for purposes of these protected absences from work. A crime victim is now defined as any person who is a victim of a, quote, qualifying act of violence. And this is in turn defined very broadly, basically any crime that causes bodily injury or death, or threatens bodily injury or death, or is a crime that is committed with a gun, a firearm, or other dangerous weapon. That is going to be a qualifying act of violence, where an employee would be entitled to these protected types of absences relating to being a victim of that crime. The other thing the changes for 2025 did was that it amended the statutes in California to transfer authority over these leave laws and claims relating to these leave laws to the California Civil Rights Department. They were formerly handled by the Labor Commissioner. They were now at the California Civil Rights Department, part of the Fair Employment and Housing Act. And with that came some new notice requirements. The California Civil Rights Department issued its own crime victim notice in the summer of 2025. All employers have to provide this notice to employees when they are hired. They have to give it to employees annually, whether or not the notice has changed. It's an annual notice requirement. And anytime an employee requests or informs an employer that their family member is a crime victim. So, multiple notice requirement sort of trigger points that you have to be aware of for this one. For employers of 25 or more employees, the 2025 amendments really expanded the reasons that employees could have protected time off from work. The additional types of leave that are permitted are for court relief, not just temporary restraining orders, but for other types of legal proceedings and legal advice, all for safety planning and relocation and securing a new residence or school for a child, providing care for a family member who is a crime victim, or providing childcare or care to a dependent adult if there's for a family member who's a crime victim or for an employee. So a lot more expanded reasons that an employee could take protected time off work. And this type of leave, this expanded leave, is generally limited to 12 weeks. In some cases, it could be even further limited, but those were kind of the major changes that we saw in 2025, and that was a lot. And in 2026, the court, we like to call this the cleanup bill because they just addressed a couple of areas that weren't as clear from the 2025 amendments, and this is part of AB 406. And the first thing that AB 406 did was there were two additional court-related time off provisions that needed to be transferred from the Labor Commissioner to the Civil Rights Department. And AB 406 did that. These leave rights are for employees who are victims or whose family members are victims of certain specified crimes. There is literally a list of specified crimes that qualify for this protected time off. And they're typically very serious felonies. There's maybe 20 or 30 of them. And employees can have protected time off to attend other types of judicial proceedings that relate to things like bail hearings, plea entries, arraignments, I guess, sentencing, parole decisions, any type of judicial proceeding where the right of the person is at issue. So those have also been transferred to the Civil Rights Department authority. They should be part of your crime victim leave policy. So if that's something you'd want to check on, make sure that they are addressed in there. So that was the first change. The second change addressed, these leaves are all unpaid, this protected time off. The employer's not obligated to pay for it. But questions came up about, what types of paid leave can employees use to be paid while they're out on these types of absences? And specifically, can they use their California paid sick leave for these purposes, even though they may not be sick? So AB 406 answered this question. Yes, employees can use their vacation, PTO, and their California paid sick leave for all of these crime victim leave purposes, including witness leave and jury duty leave, which are also types of court-related leave that are covered by these laws. So it may not have been on your radar that employees might be able to use sick leave when they get jury duty, or if they're called to testify as a witness in court by a subpoena or court order, but they can use their paid sick leave. And so what you want to make sure that you're doing this year is make sure your policies and procedures are updated to reflect these clarifications. So you might need to look at your paid sick leave policy to make sure that it addresses jury duty and witness leave and crime victim leave in general. You want to make sure your crime victim leave policy is updated to include all of the crime victim related leaves. And you want to make sure that your jury and witness leave policies, which are often separate from your crime victim and paid sick leave policies, make sure that they address the use of sick leave and permit it. So check your handbooks is the main thing here. There is also a new notice that the CRD has just put out that we will send out to you towards the end of the presentation when we get to new notices. So the other leave and benefit related new law that we wanted to go over today was AB 692. We call this, it's a prohibition on what they call stay or pay contracts. This is any contract where an employee is going to have to pay back their employer. They're given a certain amount of money, some kind of bonus, or possibly a retention bonus. And if they don't stay employed for a certain period of time, they have to pay it back. And basically those types of contracts are prohibited after January 1, 2026, unless they fall into certain exceptions. So you want to look for any type of agreement where the employer is giving the employee money or paying for something on behalf of the employee to a third party that and the employee is required to either pay the employer back or the third party back if their employment ends early. Our classic simple example here is the hiring bonus of $5,000. But if the employee doesn't stay for a year, they have to pay it back, either the full amount or a prorated amount. You can't enter into that kind of agreement after January 1, 2026, unless you have a specifically tailored agreement that is contains a lot of very particular contractual provisions and safeguards. So the bottom line for this is that it may still be okay to have these types of arrangements, but you need to make sure that your written agreement, you need to consult counsel and make sure your written agreement complies with all of the required elements to make it acceptable. Okay. So our to-dos, I mentioned before, look at your handbook, in particular, your sick leave, crime victim, jury duty, and witness leave policies. There is a new crime victims notice that was just published, and hopefully we can get that link out in the chat. If not, we can maybe send it. You can certainly give us a call on the hotline for it. And then with respect to your like retention bonuses, relocation bonuses, things like that, You want to make sure if you're entering into these types of arrangements with your employees after January 1st that you have the appropriate contracts in place to make sure that they are not in violation of the law. Okay. Any questions on the leave and benefits that I need to hit?
No, you're doing great. I did post that victims notice, the link on there. So it's in the chat if everyone wants to take a look there and needs it. But no, you're doing great. Keep going.
All right. Thanks,
You have a lot
Astrid.
to cover. Thank you.
Yeah, I know. Okay. So employee rights and protections. A couple things here. Immigration rights and immigration related protections we'll go over first, some important changes. We will also go over the California Civil Rights Department regulations on automated decision-making systems in the workplace, including artificial intelligence. We'll go over those, and then we will discuss some changes to requirements for employee personnel records and finish up with some notice and posting updates for you. The immigration-related protections come from SB 294. It's called the Workplace Know Your Rights Act. There are really two components of this. The first one is an emergency contact form. And generally, all employers have to provide their employees with the opportunity to designate an emergency contact in the event that they are arrested or detained. So, and this law was enacted in response to increased immigration enforcement and ICE raids, the purpose being for employees to know that someone in their family will be contacted if they're not going to be coming home from work as expected, so that their family member, knows what's happened, can make whatever arrangements they need, to maybe call counsel, or at least get the kids picked up from school. So these are very difficult times for employees who may be arrested or detained. It is not only, the law doesn't apply only to an employee who's arrested or detained by immigration officials. It would apply to any time the employee would be arrested or detained at work. Employers have to give employees the opportunity to designate this emergency contact by March 30th of 2026. So if you haven't been thinking about this already, now is a good time to get an emergency contact form and provide it to employees in a way where they're going to be sure to get it, a way that you regularly communicate with them and that is reasonably calculated to get there within a day, and make sure that they get it and that they have the opportunity to make that designation. We do have a form at the bit.ly link here if you need help with that. And one question we often get is whether there's a deadline for employees to respond and designate their contact. And I don't think there is. Employees, the statute does say that they can update their emergency contact during the year. There's not a limit on that. So I take that to mean that there's not a deadline. If they don't respond immediately and want to designate an emergency contact later, they can do that. So before we leave this topic, what is an arrest or detention that would trigger an employer's duty to notify an emergency contact? Well, anytime an employee is arrested or detained on the work site, first of all. And secondly, if the arrest or detention is off-site but occurs during work hours or when the employee is performing job duties, if the employer knows of the arrest or detention, then they also have a duty to notify that emergency contact. There are pretty significant penalties for failing to allow employees to make these emergency contact designations, or for failing to, actually follow through and call the emergency contact if needed, and those can be up to $10,000 per employee. So it's an important law. The other part of SB 294 is a separate notice requirement called that the Labor Commissioner publishes, the Workplace Know Your Rights Notice. Employers are required to distribute this notice to employees by February 1st of this year. The Labor Commissioner has published the notice. So if you haven't been thinking about that yet, now's the time, because you just have a few days left in January to meet that February 1st deadline. You have to distribute this notice again in a way that the employees are likely to receive it within a day. You don't want to you know, you don't want to put it somewhere that they never look, or, you know, and it has to be given to them. You can do it personally by email or text as long as it's reasonable, you know, to expect them to get it. This, like the crime victim notice, has to be distributed annually to employees and also, of course, to new hires who you may hire after February 1st. So this will be an annual notice requirement that you need to add to your list. So we mentioned automated decision-making systems. We hear a lot in the news about AI. We hear about it every day. We hear about AI and employment occasionally. California, the Civil Rights Department issued some regulations about the use of artificial intelligence in employment decisions. These regulations were effective in October 1st of 2025. And first of all, they define what they mean by artificial decision-making systems. We're talking about any kind of computational process that is either making an employment decision or facilitating a human to make their decision about things like hiring, firing, promotion, training, salary, you name it. And an automated decision system can be something, like broad categories would be like computer-based assessments or tests, questions or puzzles that you're giving to make assessments about applicants or employees or to measure their skills, or maybe something automated that is measuring a personality trait or attitude, or screening or evaluating applicants or employees. It can also include types of systems that direct your job advertisements and other recruiting materials to targeted groups, or like automated resume screeners that are looking for particular terms or patterns. Certainly any automated systems that are analyzing, people's word choice or their facial expressions. And this does include data acquired from third parties as well. So it's pretty broad. It includes artificial intelligence, but that's not the only thing. It's any kind of computational process that is going to assist in the decision-making process. ADS does not include, and this is, I guess, a happier note, at least we know what it doesn't cover a little bit, things like word processing or spreadsheets, data storage, things like that. It doesn't apply to, database technologies, calculators or data storage type systems. But it is pretty broad. And the important thing about the regulations is that they clarify or reinforce that the Fair Employment and Housing Act applies to these situations. The Fair Employment and Housing Act that protects applicants and employees from discrimination based on protected characteristics. The reason it's different and we're talking about it so much for AI and ADS is because these kinds of systems can result in what's called adverse impact discrimination, which means, a not necessarily intentional discrimination, but a neutral seeming process that results in disproportionately large adverse outcomes based on protected class. So it's a little harder to find, and is more dictated kind of by its results than anything. So AI tools have gained a lot of popularity for employment uses, but employers, should be aware that, any automated type systems they're using to help screen or weed out or make their decisions are going to be looked at. And if there is adverse impact discrimination, the employer will be liable for that. So the other thing that the new regulations mention is that if, employers, if they use anti-bias testing to try to help make sure that their processes are not resulting in adverse impact based on protected class, that the regulations suggest that that will be helpful in defending against an adverse impact-based discrimination claim. The regulations set a record retention requirement. It's a new requirement for all ADS-related records that need to be kept for 4 years from the date they're created, or the personnel action that they are involved in, whichever it is later. So this is a new and emerging area of the law, and the record retention is certainly important, as is reflecting on your processes and determining which parts of them may include automated decision making. Okay, another new law, SB 513, much easier to get your head around, I think, than the automated decision-making system regulations. This new law requires employers who maintain education and training records to keep those in the employee's personnel file. And if you do keep education and training records for employees, those records have to include this bullet pointed list here: the name of the employee, the name of the training provider, duration and date of the training, the core competencies of the training, including the skills, maybe the software or equipment that it's training the person on, and any resulting certification or qualification. These do need to be included in the personnel file. And once they are in the personnel file, they will become subject to the longstanding rules in California about personnel records. As you may recall, employers have to provide current and former employees the right to inspect or receive a copy of their personnel records. The law was previously written to include records relating to the employee's performance and any grievance concerning them. It now includes education and training records if the employer has those. And if you get a personnel record request, you do have to respond within 30 calendar days, and there are fees, penalties for not complying. So if you have education and training records and you're not putting them in your personnel file, or they may not be meeting these standards here, you'll want to take a look at that for 2026. Make sure that your process of keeping them and maintaining them in the personnel file complies with the new law. And finally, we have some new labor law posters and notices for 2026 that employers should be aware of. The first one is the first change, postings that have been updated, is Cal OSHA updated its safety and protection on the job poster over the summer. It quietly updated its poster without a lot of fanfare, but there is a new one dated July 2025. Similarly, the California minimum wage order poster is updated for 2026. If you do have employees in localities with minimum wages, there is likely a poster that goes along with the local minimum wage there, so you would want to make sure you have that. The Labor Commissioner updated its Healthy Workplaces notice. This is its poster about California paid sick leave. So that has been updated for 2026. That's a required posting that you should have. These, with the exception of the local minimum wage orders, are all on CEA's 2026 labor law poster, which is available. I guess we should take the word pre-order off of there, because they are already finished and ready for purchase. The EEOC has not changed its Know Your Rights poster. This is the federal anti-harassment, anti-discrimination poster. It's been marked as undergoing revision since about January of 2025, or maybe February of 2025, but it hasn't been revised yet. But that's something just to have in the back of your mind if you're thinking about poster revisions, there may be a new one coming. Finally, we've gone over a couple of updated notices that you have to physically give to employees as opposed to being up on a poster. There's the new crime victim notice from the Civil Rights Department, and there is the Labor Commissioner's new workplace notice of rights which has to be given by February 1st. So make sure you're aware of those. Let's see. And just employee rights, just to sum up our to-do list, make sure you're ready with that emergency contact form if you haven't done so already, in addition to those notices and posters. Give some thought to your ADS processes in your employment decisions, what you might be using, and the new record retention requirement with respect to that. And then make sure if you have training and education records that you are keeping them as required by the new law. We do have sample forms for the emergency contact, as I mentioned, that can help you with these things. And we are happy to talk to you with any questions on the hotline if you have any. A few other things just to make sure you're ready for the new year. Again, your labor law poster, there's some QR codes where you can, and bit.ly links where you can be directed for all of these things. If you need to update your employee handbook, we can help you with that. And if you need to complete your harassment prevention training, this has to be done every 2 years. The harassment prevention training for all employers with 5 or more employees are required to provide that to all of their employees. So those are 3 things to keep in mind for the new year. And if you are interested in our memberships, here is our 3 levels of membership and what goes along with each. I'm going to turn this back over to Anna in a moment, but I do want to thank the City of Glendale again for sponsoring this webinar and for giving us the opportunity to speak with you both here and on their hotline. So I will go ahead and turn it over to Anna.
All right. Thank you, Virginia. And thank you, Astrid. Fast and furious in the chat and the Q&A. This is just what we do here at CEA. We've got you covered here, my friends. So we do have a couple extra minutes. So if you do have any final questions, this is your time to pop those into the chat or Q&A while you do have this direct access to our amazing trainers. But I do want to make sure that you take a little action on the screen right now. So either if you have your phone, if you want to snap a picture of that QR code, I also just drop the link into the chat for your convenience so you can choose your own adventure, but we would love to hear from you. Again, it's only 5 very brief questions. Most of them are multiple choice. So that is also how you suggest topics that you would like to see in the future. So this is really where we do take to heart what you would like to see and how City of Glendale can help support you and your organization. With that, pop these in the chat as well. If you are joining us for continuing education credits, we do have some codes for you. So they're in the chat as well for you. Your HRCI code is 728542. Your SHRM code 26-FJ24C. You can always call into that hotline, or email us at ceainfo@employers.org. And we are more than happy to guide you on what to do with redeeming those codes to ensure that you are getting the credit should you be eligible for certification. Just making sure I'm covered in the chat here. Oh, we have someone from the Senator's office. How awesome. Thank you so much for checking in and for sharing that feedback. We appreciate that, Carlos, very much. So with that, I think we just had one outstanding question. Is there a due date for the crime victim notice? I think, is that one February 1st? This is why I just do support.
No, the crime victim notice has to be given. February 1st is the Workplace Know Your Rights notice. That's a brand new one that has to be given out by February 1st. The crime victim notice has been updated from its version from July of last summer, and that is supposed to be given out annually to new hires, and if an employee asks for it, or that they are a crime victim. So we don't have any. It doesn't necessarily have to be given out to all of your employees immediately. I think you need to be ready with the new notice for any new hires, or if an employee needs it. And if the annual date to distribute the notice is coming up, you'd want to give the new one rather than the old one.
It's just we've just got a team of experts ready to give you such polished answers like that. So with that, I know we are winding down. So I do want to say thank you all for joining us and taking time out of your afternoon to spend training. I know it is a busy time It's a crazy time right now. So thank you so much for dedicating the time to join us live here and bringing such thoughtful and insightful questions. Jennifer Coronado, who is here from City of Glendale, did just pop in that hotline for Glendale businesses. And again, I already have the email queued up. I'm just going to pull the report from Zoom as soon as it's ready to send you all the PDF of today's slide deck so that you have those for reference, because I know sometimes Zoom does not like us downloading those PDFs. So I appreciate your patience there if you were not able to download it, but look for that email from me shortly. And then again, thank you, Virginia. Thank you, Astrid. Thank you, Jennifer, and your team over and Sev for everything that you all do for employers in your area. And we look forward to working with you all soon on another training and certainly working with you on the hotline. Thank you all, and we look forward to working with you soon. Cheers.